So I've come up with an idea for a product and my goal is to license it to a company. The first step is protecting my idea. And I've seen multiple takes on what kind of patents protection I should get. Here's some information on my product. It will be an accessory to a product for an existing company, less than 10 inches at its longest point. It'll be made entirely of plastic. A slightly complex design will probably cost 3 cents to produce. Let's see, and it goes on to talk about based on the research I've done so far, getting a provisional patent seems like the best course of action. So I can protect it while I pitch it to companies for a year. However, some sources say filing a provisional patent is terrible and worse than filing none at all. So with the information I've been given, should I file a provisional patent, utility patent, or do something totally different to protect the idea? Great question and very thoughtful. It looks like you're gathering some information, researching on your own, talking to some colleagues about what you should or shouldn't do. If you think what you've invented, right, what you come up with, and this is the plastic design part, very low cost, even if it's simple, if you think it's the first of its kind, right, nothing has ever been done before like it, you ought to go have a conversation with a patent attorney and do some research first, have it done professionally to look and see, is this really novel? Is it non-obvious? And does it have enough utility to move forward and have patentability? If it is, it meets all three of those criteria, you should file at least a provisional patent application. And I highly encourage you not, as an inventor, not to draft that provisional on your own. It is something that will form the basis of the formal non-provisional patent application. I think that was mentioned in their question. The non-provisional is what is examined at the patent office, and that will eventually become the claims that you own at the end of the granted period. The provisional is what can provide you up to 1 year of, call it, ability to go to market, test your product, build it, and iterate on it. So that 1 year period of time is essentially an additional time period that you get where it's locked in. The only problem, and one of the biggest problems that we see, is that during that period of time, if you didn't write a robust enough, a broad enough claim, or broad enough provisional, when it comes time to write the non-provisional, you now have to add new matter, right? New findings. And it's different enough from the provisional that you're not able to claim priority back to the provisional application. So you might have lost. Another inventor somewhere else in the world may have filed their invention, that same invention, during that 1 year pendency, and now they have won the right to that invention, not you. So be very careful about what's filed, how thorough you are when you're writing a patent application. In this case, like I said, if what you've got is unique, you think it's got a big market potential, I would have a provisional application filed and work with a professional, a patent law firm, to get that done the right way.